Okay, for the record, this is going to be position number 38, State of Georgia versus Willie Ernest Williams Jr. Mr. Williams is charged in warrant number 2022 WA 08061 with committing the offense of simple battery. Mr. Williams is charged in warrant number 2022 WA 08062 with committing the offense of criminal trespass. Mr. Williams is here being represented by Mr. Lane, and the state is being represented. I almost called you Miss Ferguson again. Miss Jefferson, not Miss Ferguson. Miss Jefferson, please swear in your witness and present your case.
Officer, if you can raise your right hand. Do you swear or affirm the testimony that you're about to give in these proceedings is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, I do.
And could you state your name and where you're employed?
Officer Farley with Clayton County Police Department.
And were you so employed on the 13th of May, 2022?
Yes, ma'am.
And did you respond to 34 Upper Riverdale Road, Riverdale, Georgia, in Clayton County and regarding a domestic disturbance?
Yes, ma'am.
And the charges of simple battery and criminal trespass, can you tell us the basis for those charges taken against Mr. Williams?
Yes, ma'am. So I received a call at the location that a male, Mr. Williams, was at the location, which was the victim's job location, and that a security officer was currently breaking them up. When I arrived on scene, I pulled to the back. At the time, I could see the security officer, the witness, in between the victim as well as Mr. Williams, who was returning the phone back to the victim. When I got up to them, I spoke with the security officer who advised, she seen them going back and forth, and she stepped in when she saw Mr. Williams push the victim during the argument. And after talking to the victim as well as the offender, it led to that point because her phone was taken by Mr. Williams, who admitted to myself that he took the phone because it belonged to both of them.
You said he took the phone because it belonged to both of them. Can you be a little more specific as to how that was determined?
Yes. So he stated that he took the phone from the victim when she walked out the door because it belonged to them previously when they owned a business. It was their business phone at the time. The victim stated that they did not own a business together, and that was her personal phone. And she showed me phone numbers, pictures, and videos, basically showing me that it was her phone and not a joint phone.
And the phone, was that the taking of the phone, was that the basis for the criminal trespass warrant?
Yes, ma'am.
And were there any visible injuries that you saw on Miss Moss?
No, ma'am.
And did you actually speak with her?
Yes, I did.
Did she write a statement?
Yes, she did. She stated that she had not made it to work yet. The incident location is her job, also where the security officer works. She stated she had not made it to work yet and received a phone call from Mr. Williams asking her why wasn't she at work. She said once she arrived at work, he was in the back of the building. When she walked through the door is when he approached her, snatched the phone out of her hand, and proceeded back to his vehicle where she went to grab her phone back, and then that's when the push happened.
I have nothing further.
Okay, Mr. Lane.
Good afternoon, officer.
I have
Mr. Williams never did any damage to the phone, correct?
No.
He returned the phone, correct?
Yes, that was after he was told to return the phone.
And you testified that, well, do you know who purchased the phone?
Who purchased the phone? I don't know for a fact who purchased the phone. She stated that it was her phone. He stated that it was a phone that was bought by the both of them for business.
And did you run any criminal history on Chiquita Anderson, the alleged victim here?
I did not.
And who made the call in the first place to have you come out to there? Do you know who made the 911 call?
I do not recall.
So it's possible it was my client who called 911?
It could be possible. Yes, sir.
And you said there were no injuries on the alleged victim?
No, sir.
I have no further questions, Your Honor.
Okay. Ms. Jefferson, any follow-up?
No, Your Honor, no additional questions. The state rests.
Okay. Officer Farley, I just have a couple questions for you. With the criminal trespass, did I understand the testimony correctly in that the phone was taken but then returned?
Yes, it was taken once she walked out the building when she first arrived at work. He took the phone. He was going back to his car. The victim stated that she believed he was taking the phone and leaving. Once she followed him back to his car is when they were going back and forth. She was asking about her phone. That's when she was pushed. The security officer then got off the vehicle, made contact, and as I was pulling in, the security officer was making Mr. Williams return the phone back to the victim.
Okay. And the fact that he returned the phone, is that why you charged with criminal trespass and not theft by taking?
That's affirmative.
Okay. Okay. Does anyone have any follow-up questions based upon what I just asked?
No, Your Honor.
No, Your
Okay.
Honor.
Okay. All right. May Officer Farley be excused?
Yes, Your Honor, and the state will submit on the evidence.
Okay. I don't have any more questions, so she can be excused. She's been a trooper today. Thank you, ma'am. You can be
Okay,
excused. Mr. Lane, do you have any argument?
Just briefly, Your Honor, we'd ask for dismissal on the simple battery, just based on the fact that there wasn't any injuries to the alleged victim here. And the dismissal of the trespass, it's unclear, like Mr. Williams bought the phone. It's unclear who actually it was. I don't even know if we really know that yet, right after hearing the testimony. And if it has to do with the taking, if there was a taking, it was only brief, and he immediately returned it. So I don't see where that rises to a criminal trespass interference with the property of another.
Well, I mean, honestly, if it's and he's not charged with theft by taking, but if it's a taking, the crime is completed at the moment of the taking. And you can take it in 2 seconds, give it back, but you still took it, is my understanding of how the statute. Now, some say it's not smart to do that, but or charge people and spend money that way. The simple battery, my understanding of the statute is that battery is when you can see visible injuries, and simple battery is when you can't see injuries. And I have here written that he's charged with simple battery. So, I mean, I think that goes through the criminal trespass. I am going to bind both of these charges over. I had a conversation with Mr. Little and Mr. Suh and Ms. Jefferson that you were not privy to about just the criminal trespass and my concern about certain issues. But I believe as a judge, my job is to follow the law where it goes. And doesn't mean that I have to agree with it. If I disagree with it, that means I have to get out and advocate and find new people to put in legislature to make different laws. But I am concerned about this charge, especially as it relates to these facts. So, Mr. Little, you're gonna have to make some new law so I can then follow the new law as opposed to follow the law that I may not agree with.
You have to get a good test case to litigate up to the Court of Appeals, right?
There you go. It's a I'm